Have you ever received a letter or email titled Hearing Notice and wondered what it actually means? In this video, we'll break down what a hearing notice is, why you might receive one, and what steps you should take next. Whether it's related to a legal matter, a workplace issue, or a government agency, understanding the process can help you feel more prepared and less anxious. Let's start by defining exactly what a hearing notice is and why it's important to pay attention to it. A hearing notice is an official communication that informs you about an upcoming hearing. This could be in a court, at a government office, or even within a company. The notice will usually include the date, time, and location of the hearing, as well as the subject or reason for the meeting. It's essentially a formal invitation, but with legal or procedural significance. Receiving a hearing notice means you are either involved in the matter or have information that is needed. There are several reasons you might receive a hearing notice. It could be because you're a party to a legal dispute, a witness, or someone with relevant information. Sometimes, government agencies send hearing notices for administrative matters, such as benefits or licensing. In the workplace, a hearing notice might relate to disciplinary actions or grievances. No matter the reason, it's important to read the notice carefully and understand your role in the upcoming hearing. When you receive a hearing notice, pay close attention to the details it contains. Typically, you'll find the date and time of the hearing, the location or whether it will be held virtually, and the specific issue to be discussed. There may also be instructions about what documents to bring or how to prepare. Missing any of these details could affect your ability to participate effectively, so it's a good idea to make notes or set reminders. Hearings can take many forms depending on the context. In courts, hearings might involve criminal, civil, or family law matters. Administrative hearings are common in government settings, dealing with issues like benefits, licenses, or appeals. In workplaces, hearings often address disciplinary actions or disputes. Understanding the type of hearing you're being called to can help you prepare appropriately and know what to expect during the process. Legal hearings are formal proceedings where parties present their case before a judge or magistrate. These can be about criminal charges, civil disputes, or family matters like custody. The hearing notice will specify the nature of the case and what is expected of you. It's crucial to attend these hearings, as missing them can have serious legal consequences, including judgments made in your absence. Administrative hearings are less formal than court hearings, but still follow specific procedures. These might involve disputes over government benefits, licensing, or regulatory compliance. The hearing notice will outline what the issue is and how you can participate. Often, these hearings are conducted by an administrative law judge or a panel. It's important to prepare any documents or evidence you need to support your case. In the workplace, hearings are often used to resolve disputes, address grievances, or handle disciplinary matters. If you receive a hearing notice from your employer, it's important to understand the company's procedures and your rights. These hearings may involve HR representatives, managers, and sometimes union representatives. Being prepared and knowing what to expect can help you present your side effectively. With advances in technology, many hearings are now held virtually. Your hearing notice will specify if the meeting is online and provide a link or instructions for joining. Make sure you have the necessary technology, such as a computer or smartphone, and a reliable internet connection. Test your setup ahead of time to avoid technical issues that could prevent you from participating fully. When you receive a hearing notice, don't just glance at it, read it thoroughly. Look for key information like the date, time, location, and the specific issue at hand. There may also be instructions about what to bring or how to respond. Missing important details could mean missing your hearing or being unprepared, which can have serious consequences. Some hearing notices require you to respond, either to confirm your attendance or to submit documents ahead of time. Make sure you reply within the specified time frame. If you're unsure how to respond, the notice may include contact information for the organizer or a legal representative. Prompt communication shows that you're taking the process seriously and helps avoid misunderstandings. Before the hearing, gather any documents or evidence you might need. This could include contracts, emails, receipts, or other records relevant to the case. The hearing notice may specify what to bring, so double-check the list. Being organized and prepared can make a big difference in how your case is presented and received. If the hearing is related to a legal matter, it's wise to seek legal advice. An attorney can help you understand your rights, prepare your case, and represent you if necessary. Even if you don't hire a lawyer, many organizations offer free or low-cost legal assistance. Don't hesitate to reach out if you're unsure about any part of the process. It's helpful to prepare a clear statement of your position before the hearing. Write down the main points you want to make and organize any supporting evidence. Practicing your statement can help you feel more confident and ensure you communicate your side effectively. Remember, being concise and focused is key. Whether your hearing is in person or online, punctuality is crucial. Arriving late can disrupt the proceedings and may even result in your case being dismissed or decided without your input. Plan ahead, set reminders, and allow extra time for unexpected delays. Being on time shows respect for the process and everyone involved. During the hearing, each party will have a chance to present their case. This may involve giving statements, presenting evidence, and answering questions. The hearing officer, judge, or panel will listen to all sides before making a decision. It's important to stay calm, listen carefully, and respond respectfully, even if you disagree with what's being said. The hearing officer, judge, or panel is responsible for ensuring the hearing is fair and orderly. They will guide the proceedings, ask questions, and ultimately make a decision based on the evidence presented. Their role is to remain impartial and consider all sides before reaching a conclusion. When it's your turn to present evidence, be clear and organized. Refer to specific documents or items and explain how they support your case. If you have witnesses, they may be asked to speak as well. The goal is to make your position as understandable and convincing as possible. You may be asked questions by the hearing officer or other parties. Listen carefully and answer honestly. If you don't know the answer, it's okay to say so. Avoid arguing or becoming defensive. Focus on providing clear and accurate information. At the end of the hearing, you may have an opportunity to make a closing statement. This is your chance to summarize your main points and reinforce why your position should be accepted. Keep it brief and focused, highlighting the most important evidence and arguments. Once the hearing concludes, the decision maker will review all the information and issue a decision. This may happen immediately or take several days or weeks, depending on the complexity of the case. You'll usually receive the decision in writing, either by mail or email, along with any next steps or instructions. When you receive the decision, read it carefully. It will explain the outcome of the hearing and any actions you need to take. If you don't understand something, reach out to the contact listed in the notice or seek legal advice. Understanding the decision is crucial for knowing your rights and obligations going forward. If you disagree with the outcome, you may have the right to appeal. The decision letter will usually explain how to file an appeal and the deadline for doing so. Appeals are often subject to strict timelines, so act quickly if you want to challenge the decision. Consulting a legal professional can help you understand your options. If the decision requires you to take certain actions, make sure you comply promptly. This could involve paying a fine, making changes, or providing additional information. Failing to comply can lead to further penalties or legal consequences, so it's important to follow through as instructed. Keep copies of all hearing notices, decisions, and related correspondence. Good record keeping can help you track deadlines, provide evidence if needed, and protect your rights. Store both paper and electronic copies in a safe place for future reference. Hearings often involve sensitive information. Respect the confidentiality of the process and avoid sharing details with others unless required. Some hearings are public, but many are private to protect the parties involved. If you're unsure about what you can share, ask the hearing officer or consult the notice. If you need special accommodations, such as language interpretation or disability access, notify the hearing organizer as soon as possible. Most organizations are required to provide reasonable accommodations to ensure everyone can participate fully. Check the hearing notice for instructions on how to request assistance. If English is not your first language, you may be entitled to translation services during the hearing. The notice should explain how to request an interpreter. Having information in your preferred language can help you understand the process and participate more effectively. If your hearing is virtual, find a quiet, private space with good lighting and minimal distractions. Test your equipment ahead of time and have all necessary documents ready. Dress appropriately and be ready to participate just as you would in person. These steps can help ensure a smooth and professional experience. It's normal to feel nervous before a hearing, especially if you've never attended one before. Take some time to prepare, practice your statement, and gather your documents. Deep breathing and positive self-talk can help calm your nerves. Remember, the hearing is an opportunity to share your side and seek a fair outcome. If you need help, there are many resources available. Legal aid organizations, advocacy groups, and community services can provide guidance and support. The hearing notice may include contact information for assistance. Don't hesitate to reach out if you have questions or concerns. Some common mistakes include ignoring the hearing notice, missing deadlines, or failing to prepare. Others may forget to bring required documents or not respond to requests for information. Avoid these pitfalls by reading the notice carefully, staying organized, and seeking help if needed. If you're unable to attend the hearing, notify the organizer as soon as possible. There may be options to reschedule or participate remotely. Failing to communicate could result in decisions being made without your input, so always let someone know if you have a conflict. Most organizations allow you to request a new date if you have a valid reason for missing the original hearing. The notice will explain how to request a reschedule and any documentation you need to provide. Act quickly, as rescheduling requests are often subject to strict deadlines. Missing a hearing without notice can have serious consequences. The decision may be made without your input, and you could lose your right to appeal or challenge the outcome. Always communicate if you can't attend and follow the procedures outlined in your hearing notice. If the hearing involves a minor or someone who cannot represent themselves, a parent, guardian, or legal representative will usually be required to attend. The hearing notice will specify who needs to be present and what documentation is necessary. Make sure all required parties are informed and prepared. Sometimes, you may receive a hearing notice as a witness. Your role is to provide information or testimony relevant to the case. Prepare by reviewing any documents or events you'll be asked about. Be honest and clear in your responses, and follow any instructions provided in the notice. Legal representatives, such as attorneys or advocates, can attend hearings on your behalf or with you. They help present your case, ensure your rights are protected, and provide guidance throughout the process. If you have a representative, make sure they have all the information and documents they need. Every hearing process comes with specific rights and responsibilities. These may include the right to present evidence, call witnesses, and appeal decisions. The hearing notice or accompanying materials should outline your rights. If you're unsure, ask the hearing officer or seek legal advice. Let's look at a sample hearing notice. It typically starts with your name and address, followed by the date, time, and location of the hearing. The notice will state the issue to be discussed and may include instructions for responding or preparing. Reviewing a sample can help you know what to expect when you receive your own notice. A typical hearing process starts with the notice, followed by preparation, the hearing itself, and then the decision. Each step has its own timeline and requirements. Staying organized and aware of deadlines can help you navigate the process smoothly and avoid unnecessary stress. Many people have questions about hearing notices, such as what happens if you miss the hearing, how to request an interpreter, or what to do if you disagree with the decision. The notice itself often includes a section for frequently asked questions or contact information for further help. Don't hesitate to use these resources if you're unsure about any part of the process. To recap, a hearing notice is an official document that requires your attention and action. Read it carefully, prepare thoroughly, and seek help if needed. Understanding the process and your rights can help you navigate hearings with confidence and achieve the best possible outcome. Receiving a hearing notice can feel overwhelming, but with the right preparation and understanding, you can handle the process smoothly. Remember to stay organized, communicate clearly, and seek support when needed. Each step is designed to ensure fairness and give everyone a chance to be heard. If you need more information about hearing notices or the hearing process, check the resources provided in your notice, visit official websites, or contact legal aid organizations. Staying informed is the best way to protect your rights and ensure a fair outcome. Thank you for watching, and best of luck with your hearing process.